Good morning, everybody. This is Joanne Butler from Aspen Publishing. We're so glad you could join us this morning for our session with Amy Schmitz and Jan Martinez about digital dispute system design. Just a couple quick notes about housekeeping issues. We are going to keep people's microphones and cameras on mute and cameras off, just because we have got a nice group of people, big group, and I think it'll be easier to manage this bigger group if we just do so via you guys sharing your questions, comments, etc., via chat and the Q&A. So if you have any questions or comments, please feel free to use that to share. So we're looking forward to a great session today. We're so happy with the response to this wonderful book. And with that, I'm going to go ahead and turn it over to our amazing authors, Amy Schmitz and Jan Martinez.
Hi, everybody. So first of all, thank you for taking time with us. Jan and I are really excited about this book and sharing with you a little bit more about sort of what went into it. Next. So this book, why now? Why does it matter? Jan and I were talking a lot just about system design, where Jan really is the guru in this area, and thinking through, well, wait a minute, AI is really changing the way we resolve and prevent disputes and the way we really create new systems and the rise in these digital platforms. It's really been a transformative time in terms of technology and dispute resolution. And we really hope that this book can be very relevant to law, policy, and tech professionals and teachers and learners. Next. So some of the foundational pillars that we begin with in the book and kind of in the introductory chapters is first of all, really thinking through technology as the fourth party. Certainly Ethan Katch and others have really talked a lot about this very foundational concept. That we're sort of bringing it into even new light and thinking through, you've got your claimant, your respondent, your neutral, be it an arbitrator, a mediator, a judge. But technology is really becoming that fourth party, and we need to respect that and be very intentional in the way we include it within any system design. Also, the innovation paradox. It's really quite interesting to see how technology creates new disputes and can be really helpful as a problem-solving tool in the toolbox. We also think about humans and where are humans in the loop? Are they in the loop, on the loop, or out of the loop? And of course, there's a heavy dose of system design in this book. Next. So we start with this visual, and certainly we did not make this up. This actually goes back to, I first saw this visual when I was part of an experts roundtable with the National Center for State Courts. I think that was back in like 2018 or 1918, I think. And I've just found it really helpful. And this really is a concept that's been around a while, but I do think it's super important to think, where is the human in all of this, right? And we're currently in a state where the human needs to be in the loop from ethical perspectives. What does that mean? It means no decision is actually made, no final outcome is there without a human being part of that process. And this is particularly important in dispute prevention and resolution, because we should think about how can we use AI and technology to augment human intelligence. Next. Also in this book, obviously, is we're thinking very, very seriously and intentionally about where technology is. And you can think about all the different ways that we think about digital dispute system design, moving from system design to digital dispute system design. You have to think about organizational needs, workflow automation, compliance, security, change management is incredibly important in this space. Also monitoring and performance and customization. So really thinking through what is the right tool for the job. This is foundational in this book, and we go into depth in these concepts. Next. So we start off, and in the book, of course, there's a really nice introduction and go deeply building on Jan's work and with her colleagues as well on dispute system design and using the 6 pillars that they first conceptualized. So I will have Jan jump in.
Okay, thanks, Amy. The notion of systems, it sounds fancy, but it just means what are the process or processes that are put together to resolve disputes. So whether it's direct negotiation, where the parties maintain control over both the process and the decision, the outcome, to a third-party facilitated process like mediation or arbitration, where you have a third party come in and either control the process and the outcome both, like with a court, or it could be just facilitate the decision, but not leave the parties to make the decision, like mediation or facilitation. And arbitration would be a private form where the third party maintains control of both the outcome and the process. So thinking about what combination of processes are put together to resolve disputes. My co-authors, Stephanie Smith and Lisa Amsler, and I were trying to come up with a way to teach our students to diagnose the situation that is calling for dispute resolution. And we focused on 6 elements: goals, stakeholders, context and culture, structure, and processes, resources, and accountability and success. Next. So thinking about goals, which I think we consider as being the most important of those 6 elements, because unless you're really clear about, given your situation, what is your goal, what are you trying to accomplish, how will you measure success, then it's really hard to know if you've done a good job or not. So the notion of goals, and there are so many possible goals. It could be equity, it could be efficiency in terms of courts, it could be party satisfaction. So there are so many elements that would be positive goals. But at the end of the day, whether you're focused on efficiency, accessibility, intervention, party satisfaction and experience, and being heard and having voice, all of those are positive goals. But unless you're really clear about which is most important, it's really hard to monitor your progress. And so thinking about all these goals, like mom and apple pie, thinking they're all good, but which is the most important and who decides? And I think one element in system design is that if you aren't clear on what your priority is, it's really hard to make the trade-offs because it may be efficiency. For example, with the court, many court mediation programs are being evaluated in terms of their efficiency. Are they making the court able to handle more cases rather than it could be party satisfaction, party experience in the court system. So really thinking about which of your goals are most important. Let's see, next, please. Second is to think about who cares. And so I think in the terms of system design, it may be design, you may be a fresh court that is able to start from scratch and really design what you want in terms of a system, or it could be that you're redesigning. It could be there's already a system in place and you are trying to redesign it to make it better. There's likely that there are people who like the system the way it is, and so redesigning may face a certain amount of resistance or political pressure. So I think thinking about system design and redesign in terms of who are the stakeholders, who cares, who's affected by the way the system works, and thinking about moving forward. So it can be the tech, in the terms of the tech that we're talking about, could be the tech developers are designing the system and the processes and the AI elements that contribute. So thinking about those, thinking about the neutrals, the mediators, the judges, the parties, certainly their lawyers, the case managers, the clerks in the court, and the regulatory authorities that may be part of the implementation process. So really thinking through who the stakeholders are, what their interests are, and who has the power to make decisions about the system design. Next. The context and culture are also critical. Thinking about, is this an emergency situation like 9/11, trying to come up with a compensation system that would deal with all those who had been injured? So that would be a claims facility that was headed by Ken Feinberg, and this was something of great urgency and time pressure. It could be a slower moving problem with injuries, and the culture may affect who cares and who's affected, who participates in that process. So really thinking about the context and the cultural elements. Next. Key element is thinking about the process. I already touched on what kind of process, whether it's facilitative or evaluative in terms of the third party and their role. Really thinking about what are the processes. How does technology make those processes more efficient, or how does technology change the whole character of the process by having parties be able to go, mediate on Zoom as opposed to in person? That was a huge cultural shift over the last few years that we've all experienced in light of COVID. So really thinking about the negotiation process, facilitation, third-party mediation process, arbitration, and the courts. And what is the role of the fourth party in each of those process elements? Next. Another is to think about the cost benefit balancing, thinking about, do you have the necessary resources and training that are going to make the process function most effectively and optimally? So whether it's in terms of financial resources, which would be key, human resources and training, data to support the decision making, the technology that is increasing and improving by the day, the training opportunities and education of the users as well as the providers, and the trade-offs among those goals that have been identified. Next. And lastly, thinking about how do you evaluate whether you've been successful with your system. Are you monitoring the data, the experience of the stakeholders? Are you learning from your experience? Are you evaluating and being able to demonstrate the success of the system? Next. So
go ahead.
Yeah, go ahead, Amy. Yeah.
So, and so we really, in thinking about this book, so we're setting the foundation, right? So we have the main pillars with which we've already provided for really kind of thinking about technology in dispute prevention and resolution, as well as the main pillars for dispute system design. And along with that, we help you understand what are the tools in the toolbox. What are these various tools that now exist? Now, we understand that it's a moving target as new technologies come into the fore, but I think it's really an in-depth analysis that you get in the book where we go through these different tools, explaining what they are and how they differ, explaining what's out there in terms of Gen AI, generative AI, general tools, but also legal RAG systems, co-counsel, Lexis plus AI and Harvey are some key examples where we have retrieval augmented generation. We've gone beyond generative AI to even create more powerful tools. We even talk about agentic AI in the book and introduce the key concepts in what makes them different. But not to be outdone, we don't ignore rule-based systems. There are still rule-based systems that are in play that are more certain, less likely to hallucinate. The Civil Resolution Tribunal, for example, uses an expert system. If this, then that. It is much more controllable and is something that we see very much in the world of the law. Also, we talk about natural language processing and OCR, and what is the value there? How do we still use these technologies in order to prevent and resolve disputes within a particular system. We even talk about metaverse and blockchain and introduce really key concepts that should be considered in the toolbox. Next. And we try to explain the difference. So you see, well, what's the difference between rule-based systems and now machine learning, Gen AI, RAG systems, agentic AI? Well, now in these new systems, the technology sits closer to the decision-making. That is a shift in the way that we are using technology in preventing and resolving disputes. Next. And these can be useful tools, right? So we have to think, okay, again, it's not all good, it's not all bad, it's how do we use these tools? So as we explained in the book are just the different ways you can use these tools to digest documents and cases and law quickly, to help in risk assessment. We see a lot of that currently. Automatic docketing, even the state of Florida is doing that within their courts themselves, using chatbots to help answer frequently asked questions, and using AI to check for abnormalities and to help perhaps to address bias. Next. Certainly, we see lawyers and litigants. This has been a sea change, which we discuss in the book, are the different ways you can use technology to assist self-represented litigants and access to justice. Really important for triaging, for wizards, for document support. Also really providing predictions and options to help with case bargaining and strategy. Again, technology being that fourth party in dispute prevention and resolution. Also speeding up processes that used to take lots of time, really lowering billable hours. Clients are asking attorneys to use more and more of these technologies in order to bring down those billable hours. Next. But it's not all balloons and rainbows and puppies. And certainly our book really does focus on the ethics and the regulatory landscape. It's important that when you are using these various tools, and we have 2 chapters that really go in deep on the difference between soft law and hard law. By soft law, we're talking about different ethical principles. We have the American Bar Association, we have ICODER, we've got various arbitral organizations that are coming out with their own soft law, their guidance. Now that has become very important, especially in the United States. Yeah, Jan.
Yes, and I think in the notion of soft law, you have professionals like the American Bar Association as an example. You have dispute resolution providers, so the professionals like the mediators, arbitrators, so the ABA, the SVAMC, Silicon Valley Arbitration and Mediation Center, the International Council on Online Dispute Resolution as examples. You have experts like the National Center for State Courts. You have government agencies, various flavors that are all generating guidelines, principles, benchmarks, and really coming up ways of measuring the effectiveness of these processes or the accountability of those agencies. So thinking about, and then developers like Microsoft and Google, they're all coming up with their own standards. So really thinking about how do we want to regulate the use and the development of these technologies. And for an example, Kerry Coley and AC has talked a lot about regulatory and performance standards. And he really outlined, he said, we can either go with performance standards or we can have information disclosure. So disclose what you're doing and the consequences and maybe some negative consequences of use. And also wait until the use is in place, and then you assess whether you have ex post enforcement. So there are different intervention points that can utilize both the soft law or going into hard law is really looking at the AI Act in the European Union is a prime example, which I'll let Amy expand upon. I think that's the next slide.
So next.
Uh-huh.
We also, of course, do focus on, as we said before, ethics, and this gets back to sort of how should we frame this, right? And we do within the book, we try to really frame it in terms of what does it mean to be technologically competent, and that can mean different things for different professionals. Next. And certainly we do talk about the AAA ICDR guidance that Jan mentioned earlier, but it just gives you, this is a slide to just give you a sense of some of the key points that come out of this sort of soft law. And we try to really dissect these different provisions and see, well, what are the commonalities, right? Confidentiality, competence, preserving fairness is incredibly important when you look deeply at these various tools. One of the really fun things is Jan and I just sitting down together in San Francisco at AALF, we actually just sat and looked at these different guidance, different laws, and tried to really dissect how are they alike, how are they different, and really collaborating together in looking deeply at the commonalities, I think was really a benefit to the book and a really great exercise to see how really common principles come out of these various guidance. Next. And as Jan mentioned, there is hard law out there, which again have these same big concepts that come out. And what I like about this visual is it gives you a sense of the way the AI Act in Europe was created. Now, again, this is in terms of juxtaposing it within the US, of course, it's very different. In the US, we do not have the same sort of hard law, except on a state basis, which is discussed, for example, the Colorado law, which is much like the EU law. But the approach is important. The approach here that the EU takes is to look at, well, where is there unacceptable risk? For example, social scoring, facial recognition, dark pattern AI, and manipulation. These are areas where all bets are off. These are inappropriate uses of generative AI. But what about high risk? And this is where we fall in the world of law. So education, employment, justice, immigration law all fall within high risk categories. So what does that mean under the Act? Next. So under the law, it really kind of parses out strict obligations when it is a high risk activity. And that again would include the law, the administration of justice, and therefore it fits squarely in dispute system design in this area and in this book. So what does it mean? Well, it means you have to have a risk assessment and have mitigation systems in place. Also really looking at the quality of the data sets, right? Garbage in, garbage out. Well, this is really important when we think about the AI tools, again, that are being used within a different AI system in terms of dispute resolution. And really logging of activities, ensuring traceability, that's something that often gets overlooked, but the worst breaches of privacy really happen in the handoff of the data, right? So that's really important to think about in terms of strict obligations under the AI Act. This goes along with documentation and making sure that all the information is provided and its purpose and making sure that there is compliance, which goes right away with clear and adequate information to the user. For example, if there is a system that is using AI in a way that could impact your legal rights, your right to a job, your right to benefits, you should know about that. You should have clear and adequate notice so you have a way that you're able to contest the use of that AI. Again, this is hard law in Europe. Having that appropriate human oversight becomes incredibly important under this hard law as well, along with robustness, accuracy, and security all come into play. Next. Now, again, as Jan explained, you've got your soft law and you've got your hard law, both of which are discussed in the book. So in terms of hard law, as we've mentioned, you have, of course, the EU, but also discussed Australia has some. There's other areas where we do see some hard law, Colorado, as mentioned earlier, but soft law is really winning the day currently in the US. So as I mentioned earlier, we sat down and really dissected the soft law in looking at what are the themes that come out of these various bodies? When you look at ICODER, when you look at the AAA, when you look at these different groups that have come out with their own guidance, even looking within companies like Microsoft. Well, some of the key Themes for best practices that you can dissect out of the soft law include, number one, accountability. There has to be some way for accountability. Now, this goes right along with, of course, if you're a lawyer, there's accountability because we see ethical provisions. The American Bar Association has put forth an opinion on the use of generative AI, for example. So there is some accountability. Additionally, again, transparency and explainability. It seems as though we're a broken record, right? Making sure that you're transparent in the use of these technologies. And certainly with generative AI, it's particularly important. Equal, fair, and impartial, once again, become very, very important themes, and attention to privacy and security should never be overlooked. Incredibly important when it comes to use of AI within dispute resolution. Next. So kind of breaking down some of these key themes that you see in the soft law is, data management. Again, how are you maintaining this data? How are you using it for continual monitoring, learning, and evaluation? As Jan mentioned earlier, which is a really great point that she has often made in her work, is that it's not just the design, it's the redesign, right? It's not a one and done when it comes to dispute system design, and certainly when it comes to digital dispute system design. You have to be constantly thinking about how can we use the data in order to revise and improve a system to make it more fair, more effective, to serve the goals with the resources that you have. Data quality, once again, see a lot of the soft law is using the same concepts that you saw in the hard law with the EU AI Act. Outcome consistency is very important when you are using technology within a system where there are many disputes that are being resolved using that system. Well, you should have outcome consistency when using the same inputs. You should get the same outputs. Additionally, how can you audit the system? There's a lot of talk about auditability, and even NIST, which we talk about, the National Institute for Standards and Technology, is still working on that area in the United States to create guidance around auditability, around risk mitigation. In fact, in the teaching materials for the book, we include a very in-depth extra bonus exercise where you can have your students work through some of the most recent NIST guidance. And we also do provide a sample answer to make it easier for you to use. Next. Transparency and explainability, as I mentioned earlier, it's a broken record. Same thing. Where is this data coming from? Source transparency. Context and culture does matter even when it comes to the ethical use of this technology. Automation transparency, knowing that you are impacted by an automated use of data, and certainly within technology and now in the age of AI. We hear a lot about bot arbitration, for example. Well, you need to know that something is being operated with a bot at the driver's seat, right? Information processing, also incredibly important, and being able to explain how these different technologies are being used within a system. Next. Again, equal, fair, impartial. It is so important in today's day and age that we have essentially an AI arms race where different firms with more power, with more data, have the best and brightest use of AI. Well, how does legal aid compare with that? How does a self-represented litigant compare with that? So we need to think about systemic advantage. And what are the concerns there? If you are a neutral, for example, and you're seeing use of AI within a system, you need to be cognizant of systemic advantage. Also, access to system features. This is tremendously important when it comes to considering design and trauma-informed design. We talk a lot about user-centric design in the book because it's really important. You have to make sure that everyone is able to use the features within a dispute resolution system. Bias, incredibly important theme that we do think about. It's not just bias in the data itself. It also can be really human plus machine bias, anchoring bias that occurs when a neutral is focused on some particular data, what the AI said, right? Are they still using that independent human judgment? Next. Certainly, again, privacy and security, we talk about industry standards and ISO, for example, and you should always be aware of these systems. Really, especially within a system, should be following the various industry standards, chain of custody, as mentioned earlier, really thinking about risk mitigation for breach, Law firms that are using AI within their own systems, such as Harvey, for example, they have to think very deeply about risk mitigation because any sort of a hack can be very detrimental to their clients and to their business. Data storage and retention is really important in having these various policies. Again, using AI, using these technology tools within a system gives it a lot of power. So with that power comes a lot of responsibility, right? And certainly within privacy and security. Next. So again, just giving you a sense of the structure, and you can see, if you get a copy of the book, you can see how it's structured in terms of the background. We do in the first part of the book, it's really setting all the foundational concepts. It's giving you those in-depth chapters about the different technologies, about the soft law, the hard law, and really giving you a lot of tools that you can use within your class. Now, in addition, there are 9 chapters, each chapter with a case study, where we apply those foundational concepts, literally taking everything from the first half of the book and applying it to particular examples in the real world and thinking through, well, how would we really dissect this particular use in a system using technology within a dispute resolution system? These are just a few of the examples. One chapter looks at Utah's online dispute resolution platform for small claims. And it does a deep dive in applying the 6 pillars and applying these ethical considerations within the context of Utah's online dispute resolution system, which is quite unique because it was homegrown. It was created in the state of Utah, where they did not hire a vendor, but they instead created their own system. So this really gives an in-depth analysis and gives you a good way as an instructor, as a teacher, as a learner, to help students walk through, how do I actually apply these 6 pillars? How do I think about this in depth? And of course, we have exercises in the book as well. Co-parenting platforms, there's also a chapter that really looks at the ways that technology is being used within these platforms, such as Our Family Wizard and Co-Parenter. Some really interesting uses of AI in helping, for example, reframe arguments, right? Helping individuals not be abusive in the way they communicate in a co-parenting situation. We do talk about metaverse hearings, so that's kind of fun and something students quite enjoy thinking through. Yeah, the metaverse was used in a court hearing in Colombia, and we talk about it in the book and go into depth about that use. What's the good? What's the bad? What's the ugly, right? Was it good use of technology, or was it more flash, more flash than substance, right? Something fun for you to discuss with your students. We do talk about blockchain arbitration. That's another one that students kind of enjoy because it's different. Claros, it's a real company, and they have created a blockchain-based arbitral forum. Now, that may sound like a lot and a lot to tackle, but in the case study, we give you the background. We help you sort of think it through in a way that's easy to understand, hopefully, and then apply the 6 pillars for dispute system design in thinking through that use of technology. Is blockchain the right tool in the toolbox for arbitration? Something for you to talk about with your students. Mass arbitration, that is definitely a really popular subject right now in the use of AI in mass arbitration. And we discuss it and we break it down in the book in one of the case studies. Next. Finally, in the last chapters, we really kind of bring everything together and we try to look at, well, what are the threads we can sort of bring together? What are the various ways that everything you've already been talking about, how does that background information, setting the framework, thinking about system design, thinking about the tools in the toolbox, then applying the framework directly to these case studies? So what? What are the takeaways? And that's where the last 2 chapters really come in, where we try to think through what are the themes what did we learn here, right? And there's some really in-depth exercises in those final chapters, so you can really invite deep analysis with your students to think about technology and dispute resolution. Some of the key things we do talk about is, number 1 is user-centric, human-centric, and ethical system design. Ethical by design. You have to think about ethics before you begin designing, while you're designing, and after in terms of monitoring. Interdisciplinary collaboration, the importance of really getting everyone at the table. It can't just be a bunch of lawyers. You have to work with the technologists when you are thinking about system design, thinking about the regulatory authorities, thinking about the user and doing user testing to be sure that that system actually helps real people with real problems. We do, of course, think about frameworks, not only for the actual system design, but also for ethics. And how do we think about fairness, accountability, and innovation within those 6 pillars for system design? And obviously, flexibility comes into play in really thinking through the evolving technologies. And this is where we do start talking about agentic AI and the next systems that are on the horizon. Next. So some of the key takeaways again, it's a tool, technology. It's not all good. It's not all bad. It's how you use it. Ethical use is essential and acceleration will continue. And I have to say, I'm going to ask Jan to jump in here on some of the other takeaways that she'd like to add, because we really had some really robust and awesome discussions. I'm just really thankful for this time to work on this book with Jan, because some of those conversations just were really, really helpful in putting this together.
Thanks, Amy. It was fun, and I hope you as teachers will be able to integrate this into your teaching. As Amy previewed at the beginning, we really wanted to give a choices on how you might integrate this into your teaching. So whether you're teaching a whole course on technology and dispute resolution, that would be ideal if you had the luxury. But so we've given a syllabus in the teaching materials that will guide you through design of a course, that 2 or 3 credit course. We also realize maybe you teach mediation and you just have time for 2 sessions, whether you can integrate some of the technological tools as well. And so we've given that as an option, how you might craft an addition or a supplement to your class that would fit your purposes and your students. So I think that's one issue. Something I was having a little fun with, thinking if we're in the middle of this technology, was to thinking fast and slow. So Amy and I were talking about Kahneman's book, Thinking Fast and Slow, and we thought, how does that relate to the kind of analysis and research that a lawyer or any a business executive or public official might be applying to a situation, and really thinking about what does that look like. And I asked the AI that I was working with, I said, do you think fast or slow, and how does your work really match up with reality? And he said, well, we don't think, as AI, we don't think. And then I asked, what are you going to do in the future? What are the things that you as AI are going to be able to do? They said, we'll be able to think. And so I think these are such interesting times for our students, how we teach, how AI is a tool, but is it too fast a tool for learning pedagogy? So I think these are really exciting times for looking at both the AI as a tool in very many manifestations, and also as a stretch of us as teachers and as students.
Next.
Okay.
So again, just sort of bringing it together, we really do try to kind of include these future considerations and exercises that really push that discussion, we hope. Yeah, it was just, we really hope that you can, use it in whatever way that makes sense to you. As Jan mentioned, we also understand that, maybe you teach a negotiation or mediation or arbitration and you don't have time to really go into depth on system design, but you might want to include a module or 2 or more, or however many fit within your class. And the one thing that's kind of neat within this kind of digital first format is that Aspen is also able to create bundles with other books, for example, negotiation, mediation, or resolving disputes, or one of these other books, and sort of thinking through, okay, what do I want to use within that bundle? Right. And so that also kind of allows for flexibility in the use of the materials themselves. We do think technology, it's not going away. And so really thinking through as teachers, how can we integrate considerations of AI in particular and technology in general in the classes we teach, right? And understanding with a healthy regard for the importance of the human element and explaining the human element, which will never go away, in my view, for dispute resolution. And next. Thank you. So we're excited to hear your thoughts and questions, and I know Joanne's going to jump in and help navigate that for us.
Yeah, thanks you guys. Oh my goodness, so much to think about, right? Wow. And it's really cool to sort of see how much you guys got out of this project, right? Working together and being inspiring to each other. It's clear that, you know, it was such a great collaboration. So really grateful for all the work on this and for kind of putting this out there. Because like you said, technology is not going away. So, and I love the whole idea of as AI as a tool. I think that's how we're viewing it, certainly in the educational publishing space. So yeah, just want to open it up to any questions that people on the panel might have for you guys about the book, about the content of the presentation. We'll definitely make the slideshow available for you all. I can share that out along with the link to the recording. We'll make that available as well. But just wanted to give everybody an opportunity to share any questions. One thing I know that we had gotten a question about earlier is just and you guys made some mention of this, was kind of teaching resources as you described. So maybe you guys could talk a little bit more about sort of what you're putting together, what's currently available, what you're planning to make available, how you guys plan to use the material. I think that could be helpful to folks kind of thinking about best ways to navigate this, given some people will have an ODR class dedicated and can just pick it up and use it, but others may have to kind of figure out ways to do that.
Yeah. So I don't know, Jan. So first of all, we do have some sample syllabi. Like Jan mentioned, one is for, you know, if it's a full class that you're going to teach, be it dispute resolution digital age, which is a class that I've taught before at 3 or 4 different places, or an online dispute resolution course, or a technology and dispute resolution course, or whatever you might call it, then certainly the book could just be used wholesale. But then also, as mentioned earlier, really only using part of it, right, within another course, be it negotiation, mediation, arbitration, or even just a general survey course, right? And so we also have a sample syllabus for that as well. Along with that, as I mentioned earlier, we have some kind of bonus exercises. One exercise is already there, which is a much more in-depth that you could even use as like a final exam or something, or, you know, a larger kind of exercise with your class, along with a sample answer as well to help you in navigating as an instructor. So we're going to have more of these sort of exercises. I know Jan also put in a really cool exercise. I don't know, Jan, if you want to talk about that one, because that one I think is really neat in having students actually act within a system design. And it's from the glass text case that is actually in the case book, in the book as well.
Sure. On the glass text case, we wanted to introduce the use of algorithms to determine by some formula how compensation might be made to a claimant. And so we used a case that was resulting in employees getting silicosis, a lung disease. And there was, so there's the spreadsheet with 5,000 claimants in it, and there's data on each of the claimants in terms of the years they worked for the company, how severe their medical injuries were, how much they had spent in medical expenses. So that's all thrown into it, and then students are given that data and a tentative formula, and then they're able to say, well, I think we should put more weight on the severity and not pay attention to whether they were smokers or not, as an example. And then students can calculate that. And we recommend that they work in teams, and maybe 2 or 3 people, and spend some time going through the formula and recalculating what they think would be a fair algorithmic determination of compensation for their injuries. So, and we also suggest, if you have time, is to watch the movie Worth, which is a review of Ken Feinberg's work on the 9/11 Compensation Fund and the whole notion of voice and how important it is for a claimant not just to have data supporting their claim, but also have an opportunity to be heard, how they experienced the injury. So that's an example of a more elaborate case example that you could do with your students, and they would get a real sense of the pillars and their application to that technology.
And there's even a PowerPoint included within that one. We also have a couple of videos that we're adding that you can include within your class. We did an earlier podcast that's included in the teaching manual as well. This will also be included, different things that you might want to use. And we're continually providing more information, more answers, sample answers, teaching notes, guidance on use of the book. And that's something we're continuing to add to the teacher's manual. And hopefully that will be just an ongoing resource to anybody who's interested in really considering technology within dispute resolution in whatever way you'd like. And we're really trying to, think through what would be helpful for you and what would be helpful in somebody who maybe doesn't have a big background in technology. So we're trying to make it very accessible.
Yeah, that's a great point, Amy. And I think important to note that with, this particular field, seeing how, I've worked with you guys over the past, 6 months, year or so. I'm confident that as new things pop up, you'll be on top of it, and that we'll be continuously providing updates, whether via the teaching manual or the actual book itself. As you mentioned, I'm going to just pop this up here because the book's available. You can go on to our Aspen website here, this link here, and I think one of my colleagues may pop up the link in the chat as well to make it easy to get to. But via that link, you can request access to a copy of the book. There's the table of contents. We'll be posting the preliminary teaching resources there, so you guys can take a look at that. But important to note that, this will be a work in progress, likely, right? And that, due to just the nature of this type of content, I expect there will be updates and such over the course of the next into the future, right? So we'll just encourage everybody to take advantage of the availability of the book.
And I will say, because we know this stuff gets really complicated and everyone thinks, oh gosh, technology, AI, but we try to keep it very simple and straightforward so that it's understandable. So one thing that we really focused on is we provide a lot of charts. So you get a lot of visuals and charts that kind of break things down, which will hopefully be helpful, especially for students. I know one thing that I love to do, and I did do while we were writing the book, is provide samples of chapters and drafts to students and ask them for feedback directly. I have the luxury of teaching a class that really focuses on dispute resolution in the digital age, which is directly in line with this whole area. And then I have another class called Justice Tech, where we really do think in depth around digital dispute system design and designing, building, testing technologies to help self-represented litigants. And I just love getting the advice of students while you're working on something like this, so you can be sure that they understand it, right? And it's not over their heads or too technical. So that was really important to Jan and I as we were developing the materials.
Awesome. Well, I'm not seeing any more questions. So given that it's the beginning of the school year, I'm sure everybody would appreciate a couple extra minutes of their day. We're really grateful for everyone's participation, especially Amy Schmitz and Jan Martinez. Thank you so much. We are really grateful for your partnership on this, and just encourage everybody to check out the book. If you have questions, feel free to reach out to any of us. I'll be sure to be following up with everybody on the call with a link to the recording, a copy of the PowerPoints, and then obviously if you have questions, feel free to let us know. But unless you guys had anything else to offer, I think that we can close it out and be grateful for everybody's participation. Thanks so much, everyone.
Yeah, thank you, everybody. Thanks for taking
Mhm.
time.
Yep.
Happy
Bye
working.
now.
Okay. Great.